$32.15, 43 cents.
Can you tell me, can you guys pay that?
I'm waiting on a direct deposit from my 401k for 2319. That should be here within a day or two. And I'm going to pay that. And then the remainder can be paid with my next check on June 11th.
I'm going to let you go into a breakout room and speak to Ms. Lowney. I'm going to go on to another one here, okay?
Okay.
You go into a breakout room. Everybody can go into a breakout room, and we'll go from there. I'll go on to the felony, and then I'll come back.
Your Honor, if I may, I was in a breakout room showing the video. Was Mr. Connors to meet with Lakeshore?
Yes.
Okay, thank you.
Yes. Stephen Tyler Schmidtling, 258-710-802. Detective, your name?
Good morning, Your Honor. Detective Crystal Tulas, Brownstown Police Department.
Raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got.
I do.
Go ahead.
On April 3rd of 2025 at approximately 7:08 p.m., Lieutenant Topchin was on routine patrol in a full Class B uniform operating a marked Brownstown Police Department Chevrolet Tahoe patrol vehicle 1816, which was equipped with an audible siren, emergency flashing lights, and decals reading police on both sides in the rear of the vehicle. Lieutenant Topchin was traveling southbound Dix-Toledo south of Pennsylvania Road, traveling approximately 56 miles per hour when he observed a white male later identified as Stephen Tyler Schmidtling pass him in a black Mini Cooper, Michigan plate EUK 9931, traveling at approximately 70 miles per hour in a posted 50 mile per hour zone. After passing the patrol vehicle, Lieutenant Topchin observed that the suspect vehicle slowed down. Lieutenant Topchin pulled his patrol vehicle behind the suspect vehicle and observed that the vehicle began to apply heavy brakes, almost stopping in the roadway. Lieutenant Topchin then observed the suspect vehicle cross over the center line and two northbound lanes of Dix-Toledo Highway and pull into a regulated flare lane for right turns on northbound Dix-Toledo to Watson Engineering located at 18703 Dix-Toledo. Lieutenant Topchin pulled behind the suspect vehicle with emergency lights active to perform a traffic stop, but the suspect vehicle failed to stop. Continued traveling in the flare lane at approximately 5 miles per hour, and then re-entered the roadway for southbound Dix-Toledo Highway and accelerated away from Lieutenant Topchin's patrol vehicle. Lieutenant Topchin activated his emergency siren and followed the suspect vehicle, which was still not stopping, and notified dispatch of the pursuit. The suspect vehicle continued southbound on Dix-Toledo Highway, traveling 60 miles per hour in a posted 50 mile per hour zone, turned right onto westbound Sibley Road, and then turned right again onto the entrance ramp for northbound I-75. Lieutenant Topchin continued behind the suspect vehicle with lights and sirens activated, and the suspect vehicle continued to fail to stop. After merging onto northbound I-75, Lieutenant Topchin remained behind the suspect vehicle, which was traveling approximately 80 miles per hour in a posted 70 mile per hour zone. Lieutenant Topchin witnessed the suspect vehicle make several erratic lane changes as it went from left lane to the right shoulder to avoid slower traffic. And then Lieutenant Topchin observed that the suspect vehicle was traveling at approximately 80 miles per hour on the right shoulder of the roadway to evade stopping and get around slower traffic. As the pursuit reached Pennsylvania Road, Lieutenant Topchin terminated the pursuit due to heavy traffic volume and a concern for the safety of others. After the pursuit, Lieutenant Topchin identified the registered owner of the suspect vehicle as Melinda Johnston. Lieutenant Topchin spoke to Melinda Johnston, who stated that she believed that her son, Mr. Schmidtling, was driving her vehicle at the time of the pursuit and provided a contact phone number for Mr. Schmidtling. Lieutenant Topchin attempted to contact Mr. Schmidtling to arrange a time for him to come into the Brownstown Police Department to be interviewed regarding this incident. On April 11th of 2025 at approximately 10:25 p.m., Mr. Schmidtling came into the Brownstown Police Department lobby with his mother, Melinda Johnston, to speak to Lieutenant Topchin regarding the incident. At that time, Mr. Schmidtling waived his Miranda rights and agreed to speak and provide a written statement. In his statement, Mr. Schmidtling admitted that he had been southbound on Dix-Toledo Highway on April 3rd of 2025 when he saw a police car and got scared and fled from Lieutenant Topchin because he thought he had a warrant for his arrest. Mr. Schmidtling admitted to failing to stop and getting on northbound 75 and fleeing to the city of Detroit, where he finally stopped and waited for his mother, Melinda Johnston, to pick him up. A criminal history check for Mr. Schmidtling showed 6 prior felony convictions, including the first, August 10th of 2009, felony for breaking and entering a building with intent out of the 3rd Circuit Court in Wayne County. November 19th of 2010, police officer assaulting a resisting obstruction out of the 38th Circuit Court in Monroe. And May 6th of 2011, for motor vehicle unlawfully driving away out of the 38th Circuit Court in Monroe County. A check of Mr. Schmidling's priors on his Secretary of State record for convictions for driving while license suspended showed that he had 6 priors, including a conviction on January 29th of 2025 for driving while license suspended, revoked, or denied out of the 33rd District Court.
Based on your sworn testimony, I find the crime of plea and elude fourth was committed, drive while suspended was committed. There's sufficient evidence to establish that he has the prior convictions giving rise to the fourth offense notice. You sent this over the 15th, and I believe we tried to call you back and you were out of your office, so you dated it that day. I'm crossing that out. Since we're doing the signing on record today, I initialed it and dated it May 19th next to your signature. I'll note that you signed the complaint, again, May the 19th. I'm changing that date to, and I signed the complaint and the warrant. You are all set. Have a good day. Thank you very much.
You too. Thank you, Your Honor.
Thanks. Baldwin House versus Deborah Davis, 2501566. Deborah Davis here. Mr. Butchart.
Sorry, Judge, I hadn't brought in Mr. Bouchard yet. Did you handle the, there was one that had no attorney listed on the front of the file?
I don't know. I don't know. Oh, no, I did not handle that yet. This is Sonia Regis versus Lavielle Pfizer, 2501822. Mr. Pfizer, your name?
Hello, Pfizer.
Miss Regis, your name?
Sonia Regish.
Okay, did you listen to and understand the rights, Mr. Pfizer?
Yes. Yes, sir.
Okay. Why don't you have to leave? This is for non-payment of rent. Okay, I see. It's for non-payment. Did you, do you wish to speak to a lawyer, sir?
Yes. Yes, sir.
Do you intend to apply for funding?
Yes, sir.
So, Ms. Regis, here's what I have to do. We're going to set you up with a lawyer from Lakeshore that you can speak to with Mr. Pfizer. You can apply for funding. I'm adjourning this 2 weeks. I'm adjourning this 2 weeks until June the 9th, is it, Jen?
Second, Your Honor.
Second, geez, at early, right? 8:30?
10.
10?
10.
I gave a couple others when you weren't here, 8:30 for whatever it's worth.
Okay.
You have to submit an application for funding within 5 business days. Well, you're going to wait, you're going to speak to the lawyer, and you have to submit an application for funding to the court indicating that you've submitted the application to the funding agency no later than 5 days from today. Okay?
Yes, sir.
And then I'm adjourning this until that date. You'll wait there. You'll speak with the lawyer, and we'll see you back here on June the 9th. June the 2nd at 10 a.m. Okay?
Yes, sir.
All right. Ms. Regis, any questions, ma'am?
Yeah, so I was looking to move him out of the property completely. I'm new to this. I've never been a landlord.
Yeah, that's why you should probably have a lawyer doing it, but you sue him for non-payment. If he pays up, he can stay. If he pays up, he can stay. How much is owed right now?
He's behind 2 months rent, which is supposed to be $2,000 each. I'm sorry. So we agreed to a short term.
Okay, so here's the deal.
Mhm.
You need to consult with a lawyer probably. I'm adjourning this out until that date. You need to understand that you need to have the exact amount that's owed when we come back. I don't give more than $70 in late fees. You're entitled to the past due rent. And you're entitled to your court costs, okay? But I don't really quite need to hear it right now, but you need to make sure you take care of that, and we'll see you back here in a couple of weeks. Any questions?
Okay, well, I was, yes, my only question is.
Hang on. He's disappeared now.
He went into the breakout room. I'll bring him back.
I can't do anything since he's not back here, ma'am. You're gonna have to come back June the 2nd at 10, okay? But you can't just throw somebody out if you have a contract going and you haven't done anything to terminate the tenancy. So I don't know what to tell you. That's all I can say at this time. All right?
Okay. I understand. He originally
I can't
said-
talk to you about it when they're not back here is the problem. I
Okay,
can't talk to you about it. If you want to try to wait, we'll try to get him out of here or get him back in here. But so far, it's been unsuccessful. Okay? Jennifer, are you trying to get him back in here?
I am. I'm trying.
Let's go into Baldwin House versus Deborah Davis, 2501566. Good morning. Your
Brian Butcher on
appearance?
behalf of the plaintiff. Brian Butcher, P662504 for the plaintiff.
Do I have Deborah Davis in here?
Yes, she's in. Yes. He should be back in just a second, Judge.
Having a good time with Zoom this morning, huh, Judge?
Well, I mean, it hasn't been bad, but it's just, it's just not easy to deal with. Ma'am, your name? Ma'am, your name? Ms. Davis, your name. This is what I mean. Recalling Sonia Regis versus Laville Pfizer, 2501822. Mr. Pfizer, your name again?
Lavelle Pfizer.
What do you have you wanted to ask a question, Ms. Regis? I can't give you really legal advice, but go ahead.
well, I guess what I was gonna say was me and him had agreed to originally only 6 months temporary rental. As he was inquiring, I didn't know what to do with this house after my mom passed away. He was a friend of my mom's, so I let him move in as a temporary rental. And we had made an agreement that he would be paying $1,500 a month, and then after 6 months, if we were to extend, we would move that up to $2,000, which is why I kind of stumbled there on how much he actually owed, because he hasn't
Okay,
paid
so listen,
any
listen,
of April or
listen,
May. Now that we're in May,
Listen. So far, you only sued him for non-payment of rent. You didn't try to terminate the tenancy. You need to speak to a lawyer if you want to do that.
okay.
Okay, you can't just, if in fact what you told me is just true, the lease would have expired if what you told me is true. And then you could have sent out a 30-day notice, but I don't have enough facts right before me and I can't really give you advice, but you did not sue for anything other than non-payment of rent.
Gotcha. I'm new to this. I don't know what I'm doing.
I know, yeah, that's why you probably should have hired a lawyer. I'm not trying, it doesn't matter to me, but so Mr. Pfizer, you come back June 2nd at 10. Ms. Regis, you come back June 2nd at 10. And we will see everybody back here then, okay?
Yeah,
Okay.
thank you.
Thank you.
Thank you. Do I have Baldwin House versus Davis? Deborah Davis needs to show up and she needs to start her video and state her name. Your name?
I'm sorry, my name is LaDonna Baker.
No. Deborah Davis, I need your name. Ms. Davis? Ms. Davis, can you hear me? I mean, it's just painful.
Mr. Bouchard, were you able to communicate with her in the breakout room?
Yeah, oddly enough, we had no issues whatsoever.
Marsh Creek versus Charmaine Williams, 2501574. Charmaine Williams, state your name. I think what we're gonna do is I'm gonna have to put on here, if you can't get on Zoom, I'm gonna default you.
Charmaine Williams.
All right, I already covered this last time for you. Did she submit an application for funding, Jennifer?
Judge, I'm double checking just to make sure.
You didn't submit that, Ms. Williams?
I did. Yes, I did.
Okay. we'll
Yes, she
check.
did on the 9th.
All right, have you heard anything from them, ma'am?
No, I do have a phone interview for Thursday, but I didn't hear anything other than that.
Mr. Butchart, your appearance?
Brian Butcher, P66250 on behalf of the plaintiff. Good morning.
So she's entitled to a couple more weeks. I'm going to indicate defendant submitted application for funding adjourned to June the 2nd, right?
Yes, Your Honor, at 9.
At 9 a.m. Okay, ma'am? So you have to have everything in order, because then I've got to give them a judgment if you don't have the money and whether you're waiting on it or not, okay?
Okay.
So
Judge, if I may address.
Pardon?
I just wanted to request permission to address Ms. Williams very briefly.
Sure.
Ms. Williams, we had discussed a payment arrangement. I guess I didn't realize you still had the application outstanding. Obviously, if you can make the payments that you committed to in the meantime before we come back, go ahead and do that.
Okay.
And then we'll likely entertain the same payment arrangement when we come back next time, okay?
Okay.
Okay.
Good luck.
Thank you.
Ms. Davis, can you hear me, ma'am?
Okay, that way then.
Ms. Davis, can you hear me, ma'am? Let's go on to Golden Management. Which ones did I send you to the breakout room for, Ms. Lowney?
That was Mr. Marler and then Ms. Kendra Williamson.
All right.
Your Honor, my apologies for the interruption. I do have her in 22nd District Court, so while we're waiting for Ms. Davis, I'm going to bounce over and check in on that matter.
Go ahead.
Okay, thank you.
Golden Management versus Eric Marler, 2501834. Mr. Marler, your name?
I don't know if he's still in the breakout room.
He is not.
Why is this happening? I mean, I just hate this Zoom. I'm trying to be a pal here to everybody, you know, and let them come in by Zoom, all this, but this is crazy.
I did work
All right.
out terms with him.
Let me go on to the next one.
Okay.
Golden Management versus Kendra Williamson, 2501893. Ms. Lowney, your name?
Sarah Lowney on behalf of the plaintiff.
Ms. Williamson?
Yes, sir.
Name?
Kendra Williamson?
Any resolution here, Ms. Lowney?
Yes, Your Honor, we did work out a conditional dismissal, and I can put the terms on the record.
Please.
Rent in the amount of $2,840, late fees in the amount of $150, court costs the amount of $225.43 for a total of $32,1543.
All right. Go ahead. I'm sorry.
No. Ms. Williamson is going to pay $23.19 by May 29th. And then thereafter, she was going to pay the balance plus June rent by June 11th. So that total would be $1605.43.
I'll do it on this one. I prefer to not. When June hasn't hit yet, I get it's a consent judgment. It just makes it complicated. You got now figures that she's paying that are in excess of the judgment amount, right?
Yes, Your Honor, we're not working at the.
I'm going to do it on this one. I'm
Okay.
just going to ask you not to include June rent in the future.
Okay.
Ms. Williamson, this says that you owe, and I'm going to give them a judgment unless you tell me that you don't agree that you owe this amount, $32,1543. Do you agree that you owe that amount?
Yes, sir.
You understand you have to pay $23.19 by May the 29th, and then you have to pay the remaining balance plus whatever your June rent is by June the 11th. After you pay $23.19 on this one, you would still owe, it looks like,
$896.43, I have, Your Honor.
$896.43 plus the June rent by June the 11th. You agree to that?
Yes, sir.
And this is going to be a conditional dismissal since you're unrepresented by a lawyer. You have 3 business days to come in here and fill out a motion to set aside the judgment you have, or the dismissal order. You have 10 days to appeal. Do you understand all that?
Yes, sir.
All right. Any questions for me?
No, sir.
Do I have your permission to sign the conditional dismissal, Ms. Williamson?
Yes, sir. Yes.
Yes. Okay. So she's going to sign your name to that. You understand your rights. Stick with those payments and you'll be able to stay. If not, you have to move out. If you don't, you'll be evicted. Okay?
Yes, sir.
Good luck. Where's Mr. Marler at, Jennifer? Do I have Eric Marler there or not? I'm going to keep that one out. I've got Baldwin House with Deborah Davis. And then I'm going to go on to Preston Point. Preston Point versus Harley Stevens, 2501705. Ms. Stevens, your name?
Harley Stevens.
Mr. DeRosa.
Good morning, Your Honor. Mike DeRosak on behalf of the plaintiff, Preston Point.
All right, so we adjourned this a week, actually from May 15th. I don't remember why. Can somebody enlighten me?
Yeah, Your Honor, at the last hearing, Ms. Stevens indicated she wanted to speak with an attorney. Turns out what she wanted to do was speak with me about trying to just get to an understanding. I did have a chance to speak with her in a breakout room this morning. We have reached a consent judgment, which I can.
Okay, go ahead.
There is presently rent to retain possession in the amount of $4,500, late fees in the amount of $150, which is 3 months at $50 a pop.
Remember, I give 70 a month now, just in case you're, go ahead.
Correct. Yep, the lease specifies 50 for Preston. We have court costs of $249. So the total we have is $4,899, which we have agreed will be paid on or before May 29, 2025, or Ms. Stevens will surrender possession of the premises before that.
Do you understand and agree to those terms?
Yes, sir.
So you agree that you owe that sum of $48.99 and you have to pay that by May the 29th? And if you do, you can stay. If you don't, you have to vacate. If you neither pay nor vacate, he's going to submit an application for a writ and you're going to be evicted. Do you understand that?
Yes, sir. And my plan is to vacate.
You don't need to explain that. You have 3 business days to come in here and fill out a motion to set aside the judgment, and you have 10 days to appeal this. Do you understand that?
Yes, sir.
Any questions, ma'am?
No.
I wish you well. Good luck. Thank you. You're
Your
all
Honor,
set.
Ms. Stevens did give me permission to sign her name to the judgment, so I'll do that this morning and we'll get it submitted to the court.
And that's true, right, Ms. Stevens?
Yes, sir.
You're all set. Have a great day. Preston Point versus LaDonna Baker, 2501813. Good morning, Miss Baker. Your name? You have to unmute.
Good morning. My name is LaDonna Baker.
Did you listen to and understand the rights?
Yes, sir.
Do you wish to speak to a lawyer?
No, sir.
You intend to apply for funding?
No.
Mr. DeRosak, your appearance?
Good morning, Your Honor. Mike DeRosak on behalf of the plaintiff, Preston Point.
Did you have any discussions with Ms. Baker?
I have not had a chance to speak with Ms. Baker, Your Honor.
How much is the total amount due? Can you tell me?
Yeah, the total amount, including late fees and court costs, is $2,747. It represents April and May rent that is owing.
Ma'am, can you pay that?
Yes, I can. You said 27. I have what I think 1150 today, and I can get the rest by May 30th.
May 30th is fine with us, Your Honor.
So we're just going to put it all down as a consent judgment, or I'm sorry, you didn't talk to her.
I have
Ma'am,
not had a chance to talk to her. I can break down the specifics as well, Judge, into the late.
yeah, why don't you do that? And then he's going to extend the writ date by a day for you, ma'am, so you can pay by the 30th, okay?
Okay.
All right, go ahead, Mr. Drozak.
Your Honor, at this time, there's rent retained possession owing in the amount of $2,398. Late fees in the amount of $100, representing 2 months at $50 each. Court costs in the amount of $249 for a total due and owing of $2,747. Landlord will agree to allow that amount to be paid on or before May 30, 2025.
All right, do you understand and agree to that, ma'am?
Before May 30th or by May 30th?
By May 30th.
Yeah, I understand.
And you can pay that?
Yes.
All right, so we're going to do this by way of a judgment after hearing. And you can go ahead and just make sure you make that payment by the 30th. If you don't, you have to vacate. If you don't vacate and don't make the payment, you're going to be evicted. You understand that?
Yes, I understand.
I sincerely wish you well. Do you have any questions for me, Ms. Baker?
No, thank you. Thank you.
Thank you very much. Mr. Drozak, do you have any more?
That's all I have, Judge. Thank you very much. Have a great week.
You too. Thanks a lot.
Thank you.
Have a great one. Do we have Eric Marler back in here yet?
Your Honor, I've not had him sign back in, and he is nowhere in any of my breakout rooms.
Did you guys resolve this in somehow, Ms. Lowney?
Yes, Your Honor, we had some terms, and I was going to work out a conditional dismissal with him.
Well, here's what I'm doing. We're adjourning this 1 week. Defendant left. He has to appear in order, in person, Jennifer, next time. Do you understand?
Yes, I'll put it on the notice.
I mean, he should have called back in, it seems. We had to find, he was sitting out there for the longest time, and we had to find connection. So he's going to have to appear in person. We're going to set it for May the, what time?
29th at 1:30.
May 29th at 1:30. Sorry about this, Ms. Lowney.
No, thank you so much for your help on these, Your Honor. I know we had a lot this morning, so I'll be back.
No problem. Do you have any more, or are you done?
I'm done now. Thank you so much. I appreciate you helping me out with these ones.
Have a good day. Thanks.
Thank you.
Mr. Butcher, you have Baldwin House versus Davis. Is Deborah Davis here? Is she able to? Ms. Davis, you have to state your name.
Hi.
Please start your video for me. We're having a heck of a time with yours. The lawyer's been waiting.
My video.
There
Okay.
you go. State your name. There you go.
Deborah Davis.
Mr. Butcher, she was in here on the 5th, and we adjourned it. She said she was going to provide application for funding, or she said she was going to apply for funding. Did she apply for funding, Jen?
Yes.
Judge, I'm double checking to make sure she got that form in. We did get it on the 14th.
Judge,
All right, that's a little late. You're supposed to do it within 5 days, okay? What do you want to do?
Yes.
She's entitled to 2 more weeks. Have you heard anything else? Ms. Davis?
Yes. Yes. I talked to Mr. Richard.
No, I
this
want to know
morning.
if you talked to the people about the funding.
I was denied.
Okay. Mr. Butcher, what do you want to do on this?
Judge, we spoke in a breakout room. I do believe we have proposed terms for a conditional dismissal.
Okay, go ahead.
There's $3,710 in rent to retain, $150 in accumulated late fees, $178.54 in court costs, which brings the total amount to $4,038.54. Ms. Davis has indicated she's going to pay $1,500 by the 29th of each month starting May 29th, and $1,000 by the 16th of each month starting June 16th until her balance is current.
So this is gonna be a conditional dismissal. She has to pay $1,500 by May the 29th toward the balance of $4,038.54, and then $1,000 by the 16th of each month.
Correct. So $1,500 by the 29th of each month, and $1,000 by the 16th of each month, until she's all caught up, essentially.
Do you agree to those terms, ma'am?
Yes.
All right, you fully understand the terms?
Yes.
All right, so since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the dismissal. You also have 10 days to appeal. Do you understand that?
Yes.
So every 29th of every month, starting with May 29th, you have to pay the $1,500, and then you have to pay $1,000 by the 16th of every month, starting June the 16th, until paid in full. Do you understand that?
Yes.
If you miss a payment and do not vacate, you will be evicted. Do you understand that?
Yes.
Does Mr. Butcher have your permission to sign your name to a proposed conditional dismissal?
Yes.
Okay, any questions, ma'am?
No.
I wish you well. Good luck to you. Thank you very much.
Thank you, Your Honor. That's it for me today. You and your staff have a good one.
You too. Thanks a lot. Killeen Bozam versus James Willard, 2501821. Do I have Mr. Janus out there?
No, Your Honor, if we could pass this for a moment, he was in another court and should be in momentarily.
Concord. How you doing, Mr. Mayers versus Jemiah Jones, 2501814. Good to see you, Mr. Mayers.
You too, Your Honor. Good morning.
Your appearance?
Ralph Mayers, P23815, appearing on behalf of the plaintiff.
Ma'am, your name?
Jemiah Jones.
Ms. Jones, did you listen to and understand the rights?
Yes, sir, I did.
Do you intend to apply for funding, or do you wish to speak to a lawyer?
I do not wish to apply for funding.
Okay. All right. Counsel, just tell me the total balance due, if you would.
Total balance, Your Honor, including monthly hearing charges and court costs, is $1,353.66.
Ma'am, can you pay that?
Can I be disclosed for what months those are?
I can answer that.
Go ahead.
The amount due during up through April was $714.33. May is $535, and that total is $1,249.33 on monthly hearing charges.
Okay. If I can have until the 30th, that will be great.
So you want to do a judgment after hearing Mr. Mayers, and you can just submit this as with a writ date of the 30th of May, if you're okay with that?
That sounds great. There would be a consent judgment with a writ date of June 30th. Is that correct?
All right. So, ma'am, we're going to do this as a consent judgment, whereby you're agreeing to these terms. You agree that you owe $135,366, correct?
Yes.
And you understand that if you consent to a judgment, the judgment will enter. You will have until the 30th of May to pay the writ, the amount of $1,353.66. If you pay by that date, you can stay. If you don't, you have to vacate. If you do neither one of those things, you will be evicted. Do you understand that?
Yes.
Now, you have 3 business days, since you're unrepresented by a lawyer, to fill out a motion to set aside the judgment. You have 10 days to appeal this. Do you understand that?
Yes.
All right. Does Mr. Mayers have your permission to sign your name to that proposed consent judgment?
Yes.
Do you have any questions?
No.
All right. I wish you well, ma'am. He'll sign your name. He'll send it over, and just plan on paying that by that date. Good luck. Concord versus Erratic Warnings, 2501815. Mr. Mayers?
Ralph Mayers, Your Honor, 2315 on behalf of the plaintiff.
Is this going to be you're asking for a judgment here?
Yes.
Is she here, Jennifer?
No, Your Honor, defendant has not checked in.
You didn't pay for a second filing, though, did you? Second
No.
name?
No.
So I need to adjourn this, Jennifer.
To the 29th?
We'll adjourn this to May the 29th.
Your Honor, I'm sorry to interrupt you, but I'm not available on that day. I was looking at the following Monday, June 9th. Is that okay?
June 2nd?
Can you do June 2nd? I'm kind of, or not?
No, June 9th is my next Monday that I'm available.
Do you have June 9th for me, Lisa, Jennifer?
Yes, we have June 9th. We can do that. 10:30.
What time?
10:30.
Could that be 11:30? I'm sorry.
You want it 11:30?
Yes, please.
No problem. We'll do it at 11:30. It's not like I'm sitting around with nothing to do on these. June the 9th at 11:30 in the morning, okay?
Okay, sounds good.
Concord versus Eliza O'Neill, 2501816. Ma'am, your name?
Elisa O'Neill?
Good morning to you. Did you listen to and understand the rights on the video?
Yes.
You intend to speak to a lawyer or apply for funding?
No.
Mr. Mayor's, your appearance?
See, Lancaster Village property versus.
Could you excuse me for 1 second? I have two Zooms going at the same time. I have another court that I'm jammed up with, Judge.
No problem. Here's what I'm going to do. I'm going to get off the bench for 5 minutes. I'll come back here in a few minutes.
That's terrific. Thank you so much.
No problem. And I don't have Mr. Chanis out there yet, right, Jennifer?
No, Your Honor.
Okay, so I'll be back in a few minutes. Everybody stay seated, please. Thank you. Well, doesn't know something.
It doesn't. They were done. Well, they were put up, so I assume. Oh, he looks like, I mean, he looks like he's ready, he's ready, but he's sitting there. And he's talking to somebody. I mean, he looks like he's just sitting there, so. Okay.
Hello?
Mr. Willard, just hold on one moment.
Okay, thank you. Sorry.
Hello?
Are you all set, Mr. Mears?
Yes, thank you so much for your
No
patience.
problem. We'll let Judge know.
Okay, thanks.
I'll let her know.
I was on the phone. She had actually called me, so we're good.
Oh, okay. All right.
Stay seated.
Court is back in session.
Eliza O'Neill.
Yes.
Concord versus Eliza O'Neill, 2501816. Okay, Ms. O'Neill, your name again.
Elisa O'Neill.
Mr. Mayers.
Ralph Mayers, 23815, Your Honor, on behalf of the plaintiff.
What are we doing on this one?
Well, Your Honor, this is a non-payment case.
Okay, you want to go ahead and outline how much is owed?
We have $1,080 in carrying charges. That's for April and May. Court costs of $104.33. Owing $1,184.33.
Ma'am, can you pay that?
If it's possible to get a few more days, I was waiting on unemployment. I thought I was gonna be able to use that, and I got denied. So if I can have
How about
maybe
if I enter a judgment for 118,433, Mr. Mayers, and tell her if she pays $750 by May the 29th, that you can give her until whatever you think is fair, 6, 4, 5. Can you do that or not?
Yeah, for the writ date, June 4th is fine.
So, ma'am, $750 you have to pay by May 29th. If you do that, writ date is extended until June the 4th. Do you understand that?
okay, the remaining balance would be due June 4th.
Correct.
Okay.
Can you do that?
Yes.
All right. So, and we'll do this one after hearing, Mr. Mayers, okay? $750 by May 29th. The balance to be paid is $1,184.33. You have to pay the rest by June the 4th, okay?
Okay, thank you so much.
Good luck. Jalisa, Canada. Concord versus Jalisa, Canada, 2501817. Is she here today, Jen?
No, Your Honor.
Okay, they didn't pay for a second mailing, so we're going to adjourn this to May the 29th at what time?
June 9th at 11:30.
Oh, June 9th, I'm sorry, at 11:30. Okay? One more you got, or two more. Concord versus Abbas Shah and Sheena Shah, 2501818. Are they here, Jen?
No, Your Honor.
Mr. Mayers, your appearance?
Ralph Mayers, Your Honor, 23815, appearing on behalf of the plaintiff.
Are we adjourning this to June 9th at 11:30, Jen?
Your Honor, I'm going to send an order of dismissal on this case.
Oh, okay. Case dismissed, motion. The plaintiff submit your order, please. And then I finally have, I have two more. Kendra Taylor, Concord versus Kendra Taylor, 2501819. Mr. Mayers, your appearance?
Ralph Mayers, P23815, appearing on behalf of the plaintiff. Your Honor, we'll be sending in an order of dismissal on this case as well.
All right, thank you very much. Case dismissed, motion of plaintiff. And Concord versus Samantha Rule, 2501820.
Ralph Mayers, 23815, Your Honor, on behalf of.
Are you dismissing this one or not?
No, this one still owes, Judge.
So we have to adjourn this. Well, wait a minute. This one's personal service. I believe you can take a judgment against this.
Thank you, Your Honor.
Go ahead.
Default judgment for the amount of carrying charges in the amount of $590. And we have $104.33 in costs. Total proposed default judgment would be $694.33.
And by the way, you don't have any, your late fees are $70 or less per month, correct?
I understand, Your Honor. These are only $50.
All right, so we are all set. You can submit that judgment and you should be good to go. Thank you very much. Have a great day. Nice to see you, Mr. Mayers.
You too, Your Honor. Thanks for your help. I appreciate it.
No problem. No problem. How you doing, Mr. Chanis? We'll get you out of here.
Thank you, Your Honor.
Colleen Mozam versus James Willard, 2501821. Mr. Chanis, your name?
Yes, for the record, Neil Chanis, appearing on behalf of the plaintiff.
Mr. Willard, I'm going to ask you to take your hat off and just stay right there if you would, please. I'm getting a good connection. Take your hat off. There you go. State your name.
James Willard, second.
Good morning. Did you listen to and understand the rights on the video?
Yes, Your Honor.
Do you wish to speak to a lawyer?
No, Your Honor.
Are you applying for funding?
I did, but they denied me.
All right. Mr. Chanis?
Yes.
What do you want to do?
Well, right now, we are seeking a possession judgment. We do show rent owing of $7,000. That's through May. Court costs of $186. The total is $7,186.
Oh, geez. All right. Well, I'm going to have to give him a judgment, Mr. Willard. You're going to have to be out by the 29th, okay?
Yeah, I'm just confused on how it's $7,000 when they said that it was $4,200 on the paperwork.
Because more time is accrued, more rental months have accrued.
Only one.
Well, they said rent is paid through December 31, and they say it's $1,325 a month. And I can tell you that 5 times $1,325 right there amounts to $66.25. And that doesn't include up to $70 late fees or your court costs.
Okay, that makes sense then. Yeah, I had a payment plan with them and I was paying them $2,000 a month. And then they asked to come do an inspection on the home Thursday. I don't know the exact date. I can look it up if need be. They never showed up. I sat at my home all day till 5 o'clock till I had to pick up my children. And then 2 weeks later, they texted me on Tuesday saying they needed to come to my house on Thursday to do an inspection. I let them know that I wasn't going to be there that day because I had an ear, throat, and mouth appointment. And she called and then she told me, well, I'm just going to evict you then because you just wasted my time. I'm like, I literally told you I wasn't going to be there during that time frame.
Listen, sir, you're quite a bit in arrears. I don't know that you have anything to complain about. I mean,
I kind of do. Their house is falling apart. They told me a year and a half ago that they were going to come and fix my ceiling that's been peeling for 2 years now.
The paint's peeling?
No, not just the paint. The actual the water damage to their property had it was leaking water into my kitchen, and I told them about it. They came and fixed it, and then it did it again, and they came and fixed the tub, which no longer caused the water to leak, but my ceiling is still peeling. It's still destroyed.
Okay.
It's
But
been a
you
year
haven't
and a
had, you've
half.
been able to live in the house though, right? I mean,
I
I'm
mean,
not,
yes and no. I haven't been there. Now that I'm getting my children back, I feel that it's unsafe because if the ceiling falls into on top of my children and hurts them, it's very unsafe. It's doesn't look safe.
Sounds like he's moving.
I was moving, yes.
Yeah.
I told Colleen that I was moving in June. And that
all right,
I
you
also
gotta
told
be out
her,
by May 29th, okay?
and I also told her that I was still sending her money every week.
Okay, so you
And
still, you gotta be out by May 29th though. I just want to be clear.
yeah, no, that's fine. I don't want to live there anyway. Like I told her, I was going to send her money. I was going to continue to send her money after I moved to get the balance down to
All right,
zero.
this will be a judgment for plaintiff after hearing. I'm sorry, I really am, Mr. Willard. I wish you well.
Thank you, Your Honor. I will submit it.
Thank you. Good luck,
I
Mr. Willard. Have a
appreciate
good
you.
day.
Sorry for the delay. And
That's all right. Don't worry about it. Thanks. Good
All
luck, Mr. Willard.
Take
Thank
care.
you.
Miss Paulette, we're all set.
Ms. Zenda, if you could.
Good afternoon, Your Honor. Ally Zenda on behalf of the people. Your Honor, the people would waive any potential conflict between this honorable court and the Office of the Public Defender. While the people believe there is no such conflict, people make this waiver an avoidance of all doubt.
All right, Ms. Pate.
Good afternoon, Your Honor. Assistant Public Defender Natalie Pate with and on behalf of the Public Defender's Office. Likewise, Your Honor, our office does not believe a conflict exists between this honorable court and our office, but if one were to arise, we would waive such a conflict.
Court for its part also does not believe there's a conflict either under the Michigan court rules or the cases decided there under. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Okay. Court does call the case of the people versus Demario Farrell.
Ally Zenda on behalf of the people, Your Honor.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Farrell, who stands to my right. Please state your name for the record, sir.
Demario Farrell. Thank you.
Thank you, Your Honor. As to the case, we respectfully request to set it for final settlement conference and then to address bond when appropriate.
Jury final settlement conference will be June 6, 2025, 9 a.m. Jury selection, if necessary, June 9th, 2025, 8:30. Both of those proceedings are in person. Esteban.
Thank you, Your Honor. It is my understanding that Mr. Farrell's bond is currently denied due to an alleged bond violation and then his subsequent failure to turn himself in on that warrant as ordered by the court back in 2023, I believe was the year. As to the bond violation, he does admit to that and is asking the court to consider releasing him pending his final settlement conference. He does state that he did leave the state of Michigan, where he was originally from, to go to Georgia during one of the prior bond violations. He has provided me with an updated address in Ypsilanti, Michigan, where he currently stays with a family friend. The complaining witness does not reside there. He is willing to go on tether or comply with any other terms as ordered by the court. He's asking for release today on a PR bond. My client states to me that he came into custody on the warrant during a traffic stop for lights, and to my understanding, no new charges stem from that police activity. To my understanding, his only current Washtenaw County matter is a license case. We do acknowledge that there is a hold out of Livonia, however. He does also have a potential job that he is currently in the onboarding process for in Wixom at Purin doing assembly of car exhausts. He does have a 4-year-old daughter, and he is now local to court. We are asking the court to consider his release pending the final settlement conference.
But he was almost 2 years.
Yes, Your Honor.
Response.
I would object to any modification of bond. First, he failed to appear back in April of 2023. At the time of that, there was a couple bond concerns in which he had gone to Georgia without permission, violating his bond, and the victim had also informed us he'd been contacting her since his release from jail. That didn't get a chance to get addressed because he failed to appear back in 2023. I also have concerns as to this case that our office is going to be looking into is why it wasn't charged as a felony strangulation given the facts in the police report. And I just have concerns that he failed to appear back in 2023 and had to be picked up for this case to come back around. So I would object to any modification of bond at this time.
Anything else?
Just very briefly, Your Honor, the only thing I would state as to that is that Mr. Farrell came back to the Michigan area last month, he states to me. One of his reasons was he wanted to take care of this matter. That being said, he was picked up on a traffic stop. And I would just ask that he be released pending the final settlement conference or final settlement.
It doesn't necessarily make any sense. If he came back to take care of it, he could have turned himself in at any given point. He didn't do so. He had to be picked up.
I understand, Your Honor.
2 years later. Motion for bond reduction denied. Bond will continue as denied.
Thank you, Your Honor.
Thank you so much.
Court does call the case, People versus Stephen Watson.
Your Honor.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Watson, who is approaching. Please state your name for the record, sir.
Stephen Watson.
Thank you, Your Honor. As to the case itself, we asked to set this for final settlement conference and then address bond when appropriate.
Go ahead.
Thank you, Your Honor. So I know Mr. Watson was last in front of Your Honor for a PCC, or it might have been a preliminary examination, my apologies. And Your Honor said he may consider a bond reduction if there was a plan in place as to treatment. I did reach out to the CCOP program and emailed back and forth a little bit with Mr. Brown. And he states to me that in order to be assessed, they would need either a court order for referral. So my first request is if the court would consider signing an order for him to be assessed for the CCOP outpatient program in order to continue treatment, if the court would consider signing such an order.
I don't have a problem doing it.
Thank you, Your Honor. And I did state to Mr. Watson that it would be unlikely that he would be released prior to that assessment, but I would like to make a brief argument for that if the court would allow. So, Your Honor, I have spoken directly with Mr. Watson's mother last week. She does state to me that she really would like her son to be out. She actually currently resides in Detroit and has been involved in a building fire and then has a foot injury. All that being said, she told me that Mr. Watson is there at least once every other week, visiting her, helping her with her medical needs, and is hoping that he can be released and goes home. My client, however, also resides in Ypsilanti, away from the complaining witness. He had full-time work and he has spoken to a supervisor since his time in incarceration, but if he is here too much longer in jail, he may lose that employment. He's willing to do a tether, and he has also states to me he is willing to test every single day. I do understand the court may be wanting to wait for that CCOP assessment. However, I would be asking if the court would consider his release pending the assessment as well as the final settlement conference. He does have a lot of family support. I do not believe Mr. Watson would be a flight risk or a danger to the community, and I would ask that he be released today as well, pending that assessment.
All right, I don't need a response. I'm not going to do that. I think with Mr. Watson, he was quite frankly frank with me in terms of what was needed previously. And until I see that assessment, I'm not going to change anything on that.
Understood, Your Honor. Thank you. And I will provide that order to the court today.
Well, I'm going to order him to CCOP outpatient program.
Understood, Your Honor.
Will they do the assessment on that order? Did they need something?
Yes, they will do the assessment on that order, to my understanding.
And I've signed it.
Oh, perfect.
I'll speed this along.
Thank you so much.
Assessment, see where he is, and then if it needs to be brought back before the court, contact Ms. Wyatt. We can try to figure out how we can get that done.
Absolutely. Thank you, Your Honor.
Appreciate it. Oh, the dates, his jury final settlement conference, June 6th at 9 a.m. Jury selection if necessary, June 9th, 2025, 8:30.
Thank you, Your Honor.
Okay. All right, thank you. Court stands in recess.
Martin Hernandez. All right, Norma, if you can see where Renee, oh, oh, yeah. Oh, it's Martin Hernandez. Okay. All right, thank you. Are you all ready or no? All right, they're not ready. Angel Martinez, are you all ready?
I just think that commitment to what he said downstairs.
All right, thank you.
The attorney that's here, he said you don't care.
Oh, that is so wrong. He's hired. Norma, did you call that attorney for his client on Angel Martinez? Yes. Found Christopher Bernal.
Present, Your Honor. 1 minute for now.
All right. All right, where are we on this case?
Judge, I've conferred with the state on Mr. Bernal's case and Mr. Guyana as well. I'm still reviewing discovery, Your Honor. We've got an initial offer by the DA's office. But discovery wise, I still need to review a bunch of things. They have not indicted him yet for continuous family violence or for evading. So I'm waiting on that to be resolved, and then we'll be in a better position.
All right.
That will be completed by the next setting. He will be formally indicted on those charges.
The state wishes that he gets indicted, but it's not a for sure thing. The grand jury has something to say about it.
Okay, you're right. I should have said it that way. We will be presenting it to the grand jury before the next setting.
Yeah.
All right. So your plea deadline date is going to be June 30th.
And Judge, that's for the one that's indicted now, right?
That is for the 2025 CR 005685.
Yes.
2025 CR 002116. And yeah. Yes, for those two cases.
All right, Judge, well, that'll give us an opportunity to look at stuff and confer with the state.
All right, is there anything else?
That's it, Your Honor.
All right, do you have any questions, sir?
No, ma'am. Thank you.
You're welcome.
Thank you, Judge.
Thank you.
Bye.
Oh, Judge, I'm sorry, did you say 6:03 or 6:30?
6:30,
Thank you.
but not PM.
Sounds good. Got it.
All right, thank you.
Been disclosed.
All right, just give me 1 second.
Sorry, just gonna my second. Thank you.
Have a good one.
He's outside, waiting for me. Should have told him to come in and wait for whoever.
Yes.
Bring my products.
Normally just have him wait for Mr. Bellevue. And please give him his reset form so he will have it. What page is he on? Page 8. I don't see him on page 8. Oh, Jorge Martinez. That's June 16th. All right, so if you can tell them to let them know that, tell him if he doesn't come out, he's. Yeah. All right. Okay. We'll see. Oh, yes.
Judge Angel Martinez on the docket.
Mhm.
I have an offer from the state. He arrived super late to your court. He's
Yes.
given the custody.
Mhm.
And we have a date to accept the reject based off.
I can have them bring him back tomorrow.
Can we do 2 weeks, Your Honor?
Oh, let me see. Yes.
Thank you, Your Honor.
All right, Ms. Ferguson on Angel Martinez. He's gonna come back. He has a bond forfeiture, but he's gonna come back in 2 weeks. So if you will put that for the 27th.
That's my birthday. Can you go
Oh,
the
look
day
at you
after?
having a birthday. You're gonna celebrate your birthday? How dare you? So you want it the first week in June?
Okay.
All right, Ms. Ferguson.
Wait a minute. You were gonna give me July 27th?
No,
No, you weren't gonna give me.
No, I
July.
was gonna give you May 27th.
Oh, May 20th. No, that's fine. I thought you said July.
No. All right, May 27th, Norma.
And Your Honor, you took them in for being late. Were you gonna set an bond amount on that or remanded?
No, it is remanded without bond.
Okay.
All right, thank you. Hello. Counsel, there is that case you were appointed to.
Yes.
My understanding, he is here. Just so you can introduce yourself and give him the reset form. Let me just put this date in the system and then I will take you up with your last client. Counsel, you have an update on Gonzalez?
Yes, I do, ma'am.
All right, what's the update?
I spoke with Natalie Perez, the coordinator for Esperanza Court. Ms. Gonzalez is in Esperanza Court. I have the case number if you want that.
Okay, no, that's fine. Let's bring her up. I wanted to make sure that somebody was supervising her.
Yes.
We're back on the record in 2025 CR 004712, State versus Shaina Gonzalez. We're back here for sentencing. Counsel, you have information with regards to the treatment court?
Yes, I spoke to Natalie Perez, the coordinator for the Esperanza Court. It says Ms. Gonzalez is on probation and actively in the Esperanza Court for a possession case. You want the case number? I can read that.
Oh, you can read it into the record.
It's 2024 CR 009696. I did talk with her about this pending case, and she said that does not affect her status with Esperanza Court, since this case actually occurred before she entered Esperanza Court.
Okay.
And I asked if time served would affect Esperanza Court. She said no.
All right. And so with regards to the 235 days, is that a judgment satisfied?
Yes, it is.
All right. All right, this is what the court is going to do. The court will find you guilty, follow your agreement, sentence you to 235 days in the Bexar County Jail under 1244. There's an $800 fine, time and money to run concurrent, give you credit for any time served, and the court will show that the judgment is satisfied. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, ma'am.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney, okay?
Yes, ma'am.
All right. We can go off the record. Here's the thing. I understand that you're in Esperanza Court. It is a good program. If anything happens, you're not able to get in touch with them, you can always come back over here. If I'm still here, I'll help you get in touch with them, okay?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome. Have a great rest of your day.
Thank you, ma'am.
Deputy Laura, do you need fingerprints or anything? All right, thank you. All right, who's here on Raymond Phillips? Court is calling 2025 CR 004740. State versus Raymond Phillips. Could I have parties announced?
Jason Gary here for the state, Your Honor. Stephen Gilmore for Mr. Phillips.
And are you Mr. Phillips?
Yes, ma'am.
Probation, there are no applications. Counsel, have you received all the discovery in this case and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Phillips, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do waive, Judge.
State, are you proceeding on the indictment as presented?
You are, Your Honor.
Mr. Phillips, did you review the court's admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, ma'am.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is.
Mr. Phillips, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 139 days in the Bexar County Jail under 1244. There are no applications. The state will take in consideration 2025 PF 14860. Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea?
It is, Your Honor.
State is at the plea.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
Yes, Your Honor. State exhibit number 1 with all of its attachments. No objection, Your Honor.
All right, state you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge. Wait, yes,
Anything you wish to say on behalf of your client?
No, Your Honor. I guess I will say that he did assist law enforcement in the investigation of an unrelated aggravated assault that occurred out of that same transaction where he was a material witness. So he was arrested because he consented to a search and admitted what he had on.
All right. The court will sentence you to 139 days in the Bexar County Jail under 1244. Give you credit for any time served. Take in consideration 2025 PF 14860. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. You're going to have to start making better choices. Unless, I always tell people, there's only 2 things that can happen if you remain in your addiction, right? Either you're going to end up in and out of jail, in and out of prison, or somebody's going to have to identify your body. Don't be that person.
3 years ago.
See, we don't want that to happen, right?
No, ma'am.
So let me just tell you, if you want to get help when you're released from custody, if you can't find a place, if I'm still here, you can come back here. and I will pick up the phone and call a place for you, okay?
Yes, ma'am.
All right, good luck to you.
I got one question.
Sure.
My release, when is it?
I'm sorry?
When will my release be?
Oh, it's probably gonna be midnight.
Oh, today?
Yeah.
Okay,
I
thank
haven't,
you so
here's the
much.
thing, I have no control over that. I don't know why it takes till midnight, but you probably won't be released till midnight.
Thank you.
All right, thank you.
Thank
God
you.
bless you too.
Appreciate you.
All right, who's here on Angel Martinez? Who's here on Cortez Polk? Are you all ready? All right, thank you. I don't know why I keep getting this one back. Hello.
How you doing, man?
I'm doing okay. How are you doing? All right, so you want a competency evaluation?
Yes, Judge, and I apologize. I had filed it back in April 18th, and I thought it would get forwarded to the MAC office, but they said it would probably be faster and easier to have the.
All right, so.
Have the court file. And I already let Mr. I let the client know that he's going to hopefully.
All right, Mr. Polk, you're going to be evaluated for competency.
Yes, ma'am.
I've already signed the order. So what we're going to do is we're going to recall you back here on, I know it's not going to be done, but we're going to recall you back on June 2nd. Okay?
June 2nd.
Yes. But there'll be other people here and maybe we can get it expedited. We shall see. All right, is there anything else?
No, I mean, I have another case on the docket, but for him, he's done.
All right, do you have any questions, sir?
I want to know if I can get recommended to the Salvation Army for mental health.
Oh, what's going to end up happening first is there's going to be a competency evaluation done. And because the cases you have are, they're sort of listed as violent cases, right? So they're going to do the competency evaluation before they place you in any type of facility, okay?
Okay, ma'am.
So it's going to depend on what the competency says. So I'm having you brought back on June 2nd. Hopefully we can get it expedited and we'll know what's going on June 2nd, okay?
Thank you, ma'am.
All right, you're welcome. Have a great rest of your day.
Thank you, ma'am.
All right, who's here on Kenneth DeLuz? So are we ready to proceed?
Yes, sir.
Okay. Hello, Mr. DeLuz. Oh, and no more cases. I just looked up and I know this is 12. Court is calling 2025 CR 003-795 State versus Kevin Kenneth DeLuz. Can I have parties announce?
Rick Boehner for the state of Texas. Zachary Munoz for the defense.
And are you Mr. DeLuz? Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. DeLuz, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, state will be first or tentatively amending count 2 of the indictment to reflect that the language needs to be changed from assault to contact. And we will also be reducing that charge to a misdemeanor APO and waive count 1. No objection, Your Honor.
Okay. Do you have any objections to the changes that the state has made to the indictment? All right, you understand that you have, at least your attorney has 10 days from the presentation of the indictment to prepare for trial? And do you understand these are substantive changes?
Yes.
All right, did you review the document entitled Court Admonishments with your attorney? Did you understand it?
Yes.
All right, state, and the admonishments, are you changing it to contact as well?
Yes, Your Honor. I apologize if that wasn't done.
No problem. And are you still keeping the stalking in it or no?
No, just,
Contact?
yes, Your Honor.
All right, if everyone could please initial that. Did you understand in your admonishments, based upon the state's request that this be a Class A misdemeanor, they're proceeding on a violation of a protective order contact as a Class A misdemeanor. Range of punishment is up to a $4,000 fine and up to 1 year in the Bexar County Jail. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you. Thank you. And you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea?
Yes, ma'am.
Counsel, I'm sorry, did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor, yeah.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Deleuze, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, state is proceeding on a lesser included offense of violation of bond or protective order contact. They're asking for a $500 fine to be probated. This run concurrent with 2025 CC 006406, and the state is recommending deferred adjudication. Did you understand that to be the plea? Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
No, there haven't.
Outside the agreement, the state is asking that your community supervision be for a term of 1 year, that there be BIPP, TAP evaluation, and follow recommendations. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? State, is there something you wanted to?
No,
I just want to- Then to the offense, the lesser included offense, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Your Honor. State, at this time, I'll offer into evidence that Exhibit 1 with all attachments.
No objection, Your Honor.
All right, and state, have you spoken to the complainant?
Yes, Your Honor, we have.
All right, you may be excused.
Thank you, Your Honor.
Did you review the waiver and consent to stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor, we'd like to.
Anything you wish to say on behalf of your client?
Yes, Your Honor, I'd like to just, if we court follow the current plea agreement, the 1 year deferred adjudication dropped down to the BPO. The state is aware that the complainant in this case has made contact with them. And we've also submitted sworn affidavits to where she had recanted the allegations, all of which, except for the fact that he did make contact with her on that
day in question, which I believe was the October date. For those reasons, Your Honor, we'd ask that the court did follow the plea agreement as well as a condition of probation to include just a no harmful or injurious contact with Sophia Barnes, because they are still dating and they are together.
Do y'all have any children together? All right. And then my other question is, he's on GPS, correct?
Yes, Your Honor, we're asking that be removed as well.
State, do you still want him to be on GPS?
No, Your Honor, that's no objection to its removal.
Mhm. Do you have any children?
Yes, I do. Two.
What are their ages?
Daughter's 15, my son is 8. Sorry.
All right, this is what the court is going to do. There's to be 1 year deferred adjudication, $500 fine probated. This will run concurrent with 2025 CC 006406. There's to be no contact with Sophia Yvette Barnes, 80 hours community service restitution. I'm going to order parenting classes. Once he completes those, 40 hours will be deemed satisfied. The other 40 hours will be satisfied once anger management is completed. There's to be a TAP evaluation out of custody, regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider with minors, field visits 1 time per month for 6 months, and agreed removal of GPS.
Your Honor, with the no contact order, I believe that's who he's currently residing with. So I'm
I hope he
asking.
hasn't been residing with her while he had this case pending, because that's a violation as well.
Well, no, that the bond conditions have been modified already due to the affidavit and the statements made to the state's office. That bond modification was, I think, occurred prior to the case even being indicted. And it was indicted to a no.
Well, what I can tell you is I don't lift no contact orders unless the complainant comes in and speaks with the court.
So that's my question. If she were to come in, and then would the court be open to have the?
Yes,
I guess
I'll listen to her and make a decision.
Okay.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, good luck to you, okay?
Ready to take this off?
Yeah, I just said it would be removed. All right, who's here on Daniel? Thank you, Daniel Montoya. Yes.
Yes, Your Honor. I'm in trial and we have our, I'm reviewing my jurors. I can't even talk because we've been in hearings most of the morning. And it's 227. So we're coming back at 12:45 to pick a jury. And I'd like to be excused so I can go read the jury cards.
All right, so I'll have you come over whenever you have a break, because my understanding, are you all not following this plea or?
Yes, Your Honor, there's just one little issue with regard to the paperwork. And when I was here before, I inquired whether or not, I believe he's applying for probation, and I may have filed the wrong paperwork and I went to correct that. It should just be for probation, not for deferred in probation.
No, the paperwork I have is for 2 to do. Am I reading the wrong paperwork?
No, that is part, it was 2 to do, and then there was an application. And I need to make sure that my client was psyched. He came back, I tried to visit him at the jail. There was issues there, so I couldn't affirmatively tell the judge if he wanted me to withdraw the probation application. And I need to make sure, and I talked to the state yesterday. Well, they called me.
All right, so I can tell you this has been on the docket since December 2024. So we'll have him here this afternoon. When you get a break over there, just come over here, talk to him, and we'll take it up.
Okay.
Thank you.
Thank you, Judge.
Thanks. All right, we're going on recess.
I have one other client,
Who's that?
Vivianca Sanchez.
I have that here. Yes.
I have conferred with the state and they provided an offer today.
Is she in custody?
No, she's
Where's
here on
she?
bond. Bianca?
What page is she on? All right, yes. So an offer has been tendered.
Yes. I've not had time to talk to my client about it, but it was tendered to me when I came earlier.
And how old are you?
31.
All right. We're gonna set this for a plea deadline date for May 29th. All right, once you sign the reset form, you're excused.
Thank you.
Thank you. All right, we're on recess,
What time are we coming back?
1:30.
Okay, thank you.
All righty,